Okay, welcome back, everyone, for our second morning panel. I'm Madhavi Sunder. I'm coming here from Georgetown University, and I also want to add my voice to the chorus, thanking Professor Sun and just congratulating you on what an exceptional conference. He is the king of conferences, but this one, so truly global expertise from around the world and literally standing room only on day two. It's really impressive and inspiring. We had an amazing conversation this morning. We look forward to continuing that with this wonderful panel ahead now. So we're going to go down the line with our speakers this morning, and we're going to start with Professor Jonathon Penney, who is Associate Professor at Osgoode Hall Law School in Toronto. He's also with the Berkman Klein Center for Internet and Society, where I'm also based this year. So it's great to have you, Professor Penney. Everyone, as a reminder, our speakers will have 15 minutes for their presentations. And we're going to stick to that because there's exceptional expertise and enthusiasm and engagement in the room today. So we want to make sure that we get that full time for Q&A. So Professor Penney.
Great, thanks very much. And yeah, just to add to the course, I wanted to thank Hao Chen for the invitation to be a part of this, fantastic lineup of speakers. It's also great to be back in Hong Kong. I was here last in 2018. So people ask me, like, do I notice a difference? One thing I did notice is that Mount Victoria is much steeper, right? Because 5 years ago, I hiked up Mount Victoria really easily, and this time it was quite hard. So it's definitely that, right? It's not that I'm older and in much worse shape. I'm going to be talking today about chilling effects. This idea that certain kinds of privacy threats like surveillance, unrestrained data collection, legal threats have a chilling or deterrent effect on our behavior. Our willingness to speak freely, engage online, offline, to associate, and that behavioral phenomenon. And I'm going to talk about some new research that's been done on chilling effects and some of the insights and how those implications or insights from that research have implications for how you might design data protection laws if you wanted to mitigate chilling effects. But also has implications for how we treat certain technological practices. In particular, I want to talk about automated legal enforcement, which is part of my title. Now, let me begin with this question. So why should you really care about chilling effects? And naturally, chilling effects because they concern a kind of self-censorship, self-restraint, where because of a privacy threat, because of a certain kind of threat that you're faced, you self-censor. You don't speak freely, engage freely, act freely. And so this naturally has implications for human rights. But as Julie Cohen and Neil Richards and other privacy scholars has also taught us, it also has implications for our personal development. So chilling effects have an impact on intellectual privacy, our ability to read, think, speak in intimate contexts, which is key to our identity formation, self-experimentation, and creativity. Is that it impacts on our identities and personal development. So there's an individual impact to chilling effect concerns. But there's also a societal impact as well. Naturally, if you don't feel free to speak as you would otherwise, or to engage politically, online, offline, and otherwise, that has implications for the healthiness of civil society and democracies. And in fact, in my own empirical research on chilling effects, I found that awareness of online surveillance or online data tracking, people were less willing to access privacy-sensitive content on Wikipedia. So that's really concerning. If you want to have a really well-informed citizenry, but people are chilled from accessing relevant information, that's a real concern. So there's an individual concern and a societal level concern when it comes to chilling effects. On top of that, we're living in a time where there are urgent chilling effect concerns due to ubiquitous computing, ubiquitous data collection all around us. Our handheld devices themselves can be targeted surveillance devices. New forms of tracking, facial recognition technology, bodily tracking technology combined with AI and machine learning, AI-based surveillance solutions for both the public sector and private sector, which raising the urgency of chilling effect concerns today. Thankfully, there's a growing body of new research, in ways an emerging new field which cuts across a range of different disciplines. So legal scholars, privacy scholars, communication scholars have been contributing to this new body of research. And in this body of work on chilling effects, there's some critical insights. And in a recent article in Minnesota Law Review, and I also elaborate this in a forthcoming book for Cambridge University Press, I articulate a more comprehensive theory for chilling effects, something I call a conformity theory of chilling effects. Now, legal scholars typically theorize chilling effects as a kind of deterrent effect, that a vague law would have a deterrent effect in the same way a criminal law would deter you. I argue that that's the wrong way to think about chilling effects. Drawing on extensive social theory and social science, I argue that the best way to understand chilling effects is a more powerful form of conforming and compliance effect that has a deeper psychological foundation. That is, in the face of certain threats like privacy threats, legal threats, personal threats, we have a behavioral tendency to conform with the group to which we're attached. Now, there are many reasons why we do that, both consciously and subconsciously. But in the past, those of us or our ancestors who were more willing to conform to the group when under threat were more likely to survive, right? So there's a evolutionary psychological foundation to this behavioral tendency of chilling effects. On top of that, and actually, let me give you one great example of this phenomenon, the watching eye effect, which is a body of social psychological literature, where you have experiments where participants, when they're made aware that they're under observation, and not just an observation of actual people, but when they're observation of just a pair of human eyes, but they know that the eyes are just artificial, they're not actually being watched. But in these experiments, when they're made aware of this, people act in more pro-social ways, more cooperative ways, and are less likely to act dishonestly in antisocial ways. In short, they engage in conformity, right? This theory also tells us more about why chilling effects are a real problem for society. It leads to more conformity, less creativity, less imagination in society. As Neil Richards would say, the bland and the mainstream. But it can also lead to polarization and violence. There's this often assumption that conformity means mainstream and bland and politeness. But that doesn't have to be that way. If the group norm is violence and polarization, conformity means it can reproduce those kinds of norms. And you see what the world saw on January 6th, 2021, the violence on Capitol Hill in the United States. Also, as part of this theory, I set out what I call chilling effects factors. That is, the literature shows that these factors provide a way to predict and measure chilling effects. The more uncertainty and ambiguity, the greater the chilling effect. The greater the surveillance, a more systematic observation, a more powerful form of surveillance, the greater the chilling effect. The more personalized the threat, the greater the chilling effect. And lastly, when you have more powerful forms of authority or power like big tech or big government, that also leads to greater chilling effects. Now, there are important implications for this theory and some of these research insights when it comes to chilling effects. And one of them is how you design laws, right? So chilling effects, in a sense, are the kind of harm. We laws and that we often enact them because of privacy concerns. Well, chilling effects are an outcome of a privacy threat. They're the harm that we try to mitigate with data protection laws, right? But there are ways in which we can design data protection laws better to mitigate chilling effects threats. So here's a few examples, and you can use these same factors that I set out. I talk about this in the book as almost as sort of a guide to redesign data protection. Some of these elements are already exist in many data protection regimes around the world. But first, you'd want to reduce uncertainty and ambiguity. That is, you need clear rules, transparency, and importantly, no shifting usage when it comes to data collection. You get to use the data for the reason that you collected, and you can't shift it, right? Because that creates uncertainty and ambiguity for the data subject that increases chilling effects. Secondly, you'd want to reduce surveillance and data collection. That would mean a data protection regime that aggressively enforced data minimization rules. That is, you only collect as much as you need for the legitimate need or purpose and nothing more. And that would also be aggressively enforced with little exceptions. Counterintuitively, you'd also want fewer notices. Because if you notify data subjects about data collection or the possibility of forms of surveillance, that actually increases the chilling effect. Instead, we should move away from consent-based models of data protection to more rule-based measures, where there are constraints on surveillance and data collection, rather than consent that's done through notification. You want to limit personalization. When the threat is more personal, it leads to a greater chilling effect. So you'd want to have a reduction in opt-ins or consent-based models, instead rules and prohibitions, but also the possibility of non-personalization alternatives. So if you're accessing a site, and of course you get that pop-up, do you accept all cookies? You should have the option to say no and still access the site. And that should be codified in the law. And lastly, of course, to deal with the power and authority factor, you want to have accountability, oversight, and fairness. Of course, a lot of data protection regimes, including GDPR and others, have elements of this already. But that's not the only implication that this new chilling effects research has. It also has implications for how we understand the impact of certain technological practices. And I want to talk about, in particular, automated legal enforcement, which is already happening today. But there are going to be more invasive forms of it happening in the future. And what will that look like? Well, it'll include elements of likely facial recognition technology, certainly AI, machine learning, deep learning, combined with those kinds of technologies. Probably at some point you would have, robotics playing a role, but probably, and this is evident today and in the not so distant future, you'd have a lot of these elements, right? Data-driven surveillance and detection, automated decision-making, legal and regulatory personalization, direct-to-target enforcement, and private sector partnerships. So this would be done in both the public and private sector. And that's just not me making this argument. There's a range of different scholars who've made this argument of different elements of automated legal enforcement. But there's a particular kind of sort of an example that's created a lot of sort of debate in the scholarship. And that's this notion of micro directives talked about by Anthony Casey and Anthony Niblett, two scholars, both Canada and the United States. And essentially what a micro directive is like a rule. It provides a clear instruction to a citizen how to comply with the law. But like a standard, a micro-directive is tailored to and adapts to each and every context. And what they envision, Casey and Niblett, this is delivered through digital means, right? A notice, a directive that's provided to the person, directing them with information to comply with the law. And that can be with a private legal right or a state or public legal right as well. Now, this has created a lot of debate in the literature around micro-directives. Computer scientists have debated micro-directives. How do you operationalize them? And something that Bruce Schneier, a security expert, and I recently argued in Slate that AI micro-directives are actually not too far off. And in fact, all around the world, there are instances of businesses and retailers using AI-enabled shoplifting identification, right? And many of these systems provide tailored messaging to shop owners, employees, and security staff, right, about identified threats and shoplifters. We're only one step away from those similar tailored messages to go to the target who's been detected with a warning not to, you've been detected, don't try shoplifting. And in fact, we can even think about the Digital Millennium Copyright Act as a sort of an existing forerunner of micro directives in the future. So this is an American statute enacted in 1998 to police digital copyright online. But today it's almost an entirely automated statute where you have automated programs scan online, detecting allegedly infringing copyright infringement, and they send sort of notices, DMCA removal notices to users and platforms at massive scales. Literally tens of millions of DMCA notices are sent to users and to platforms every single year. And those are in ways like a micro directive. You should remove this content to comply with the law. And there have been empirical studies, and I've done empirical studies in DMCA notices, and they really do have a pretty significant chilling effect, especially on users that receive them. Naturally, if we think about those factors that I mentioned earlier, micro directives like this have great personalization. So it leads to greater chilling effect. It would require surveillance if this is done at scale. And of course, it's going to involve likely large and powerful technology companies and also big government, leading to greater chilling effects. So this is the future of automated legal enforcement, both today and tomorrow, is deeply chilling. So how do we deal with that? I think we need more than just data protection laws. We likely also need what I call chilling effect protection laws, or maybe call them something more fancy. And they might look something like this, right? So additional laws that deal with some of these additional factors. You need aggressive forms of both government and corporate transparencies enforced to reduce, again, ambiguity and uncertainty for data subjects. You'd want to have prohibitions, perhaps, and this is being debated in many jurisdictions, bans on certain kinds of technologies in certain contexts, maybe an FRT ban that reduces certain kinds of very invasive surveillance in different contexts and other kinds of generalized regulations. Maybe you'd want to prohibit use of micro directives in the criminal law context. When you combine all of those factors, surveillance, direct-to-person enforcement, with the power of the criminal law and the threat of penalty of imprisonment, you can imagine how chilling that is, right? And lastly, in addition to the traditional constraints that you might have on government power and authority, be it human rights law, be it privacy laws or constitutional laws, for the private sector, you probably also want aggressively enforced antitrust laws, competition laws, to ensure that tech doesn't get too big and too powerful. And that's a trend we're seeing all too often today, especially with AI innovation and development, which follows on from social media platforms. And if we follow some of these directions, proven data protection laws, I think we're going to have a far less chilling future. Thank you.
Thanks so much, Professor Penney. So next we'll hear from Professor Chinmayi Arun. She is currently the research scholar in law and executive director of the Information Society Project at the Yale Law School. Professor Arun.
Thank you, Madhavi, and thank you so much to my gracious hosts for making it possible for me to be a part of this marvelous conference. I have enjoyed all the sessions and I've enjoyed meeting all the people here so much. I also want to add a thank you to Houchin's fabulous team for their wonderful hosting. Your hospitality has been incredible. I want to quickly introduce myself and then I'll tell you what project I'm introducing here. I'm Chinmayi Arun. I used to be, I used to teach in India for several years before moving to the United States. And my current roles are executive director of the ISB, lecturer in law at Yale Law School. And I am also affiliated with the Berkman Klein Center. There are many of us among you. And so, sorry, I don't know So what I'm doing today is basically giving you a snapshot of 3 projects, one old, one that's sort of currently in edits. It's a Carnegie essay. And the third is basically a paper that I've been working on for 2 years. I will describe parts of it to you. That paper is a bird's eye view on the question of transnational AI. Basically, why is it a good way to think about the problem, and what are the implications of thinking about AI as a transnational issue? So broadly, what I'll focus on today is old and new concerns about globalizing AI. And I'm very lucky that Anupam introduced the question to you in the keynote. I was very grateful for it. And then I'll get a little bit into why I am choosing to describe AI as transnational and why I think that's important. And lastly, I'm sure several of you are wondering why we should care. Hopefully, I'll be able to convince you a little. And so the old concerns that I had about AI in its international form, they're all in a book chapter that I wrote for the Oxford Handbook of AI and Ethics. It's called AI in the Global South, Designing for Other Worlds. And I'm giving you a quick snapshot of what I was concerned about 5 years ago. It was partly the one-size-fits-all problem. And so the analogy that I'd opened with is that I was concerned that the way in which AI companies were designing AI would be a little bit like housing that had been designed in cold European countries and then used in warmer climates like India, where it made no sense because in warmer climates, you want more air circulation. And in colder climates, you're sort of looking to keep the heat in. And then I'd opened with this architectural description and then gone on to discuss why algorithms and data sets can create these problems for worlds that their creators didn't fathom. I think that still exists and that Abeba Birhani has done a brilliant job of articulating what Western technology does when it tries to understand Africa without truly understanding Africa. The other, which I don't want to get into because so many people have done a great job of discussing it today, is questions of discrimination and bias. And then the last, which I'm going to explain a little bit, because I think that still surfaces in my thinking, is basically that AI, sort of multinational globalized AI, is often left to local regulators. And I think that we can all agree that not all the states of the world necessarily have the capability or the will to regulate technology in exactly the same way. And that means that there will inevitably be states in the world in which exploitation takes place, where technology is allowed to do things that it may not be allowed to do in other places that regulate differently. Now, one of the jokes that I make about some of my work is that I often deal with Anupam questions, but if you read Anupam's work about it, he will be optimistic and will show you a kangaroo catcher and will tell you that there are ways to deal with this. And I will always be describing the dark side of the problem. And so I just want to prepare you for what's to come. Sorry. Yeah. So the reason that I think that it's helpful to think about the new concerns of AI is that, well, so this is a jumble, and let me tell you what I'm trying to do here is I'm trying to describe the different kinds of questions that people are focusing on when you think of globalized AI. And part of it, I'm sure you all read the CEO's letter. CEOs say that extinction is something that we might like to worry about. In sort of more low-key ways, the conversations that tech companies are having with regulators is also how do we protect innovation, because we need to make sure that this technology is able to grow and is able to make its way through the world. And so you have a certain kind of narrative of the priorities of AI regulation that are being articulated by companies. And then you have the AI ethics frameworks, which I think that several of us are familiar with, and those come from various sources, but often in discussion with companies and often in the form of softer norms. Digital Empires, Anu Bradford's work, Anupam introduced in his keynote, and that's a very helpful way of thinking because we're in a room today where we've been discussing the European, the American, and the Chinese approach. And Anu Bradford did a great job of articulating how these three empires engage with each other in sort of setting the priority for regulation. And the last is the one that I'm concerned with and the one that I draw from, which is the law and political economy frameworks. And we've heard references to Julie Cohen's work earlier in this conference. But this is basically a take on AI that looks at the law and political economy and then sort of extrapolates from that what its implications are and what parts of it we might think about regulating. And I draw mainly on Julie Cohen's work and on Amy Kipchinsky's brilliant work. If you haven't read The Law of Informational Capitalism, I couldn't recommend it more. And so broadly, the way I'm thinking about transnational AI is in terms of two characteristics, apart from the fact that we've got these global companies that are all in a race with each other for profit making. Michael Wheel's work, along with his colleague Kira Mattis, and one of the papers is with Robert Korba. They do a great job of describing AI's global value chains, and so does Kate Crawford, where basically they're showing how these huge companies aren't exactly based in one state or the other. And I'm sorry, I'm being American-centric over here. I'm describing the American companies primarily. And so the people involved in the construction of what looks like neutral magical technology are actually scattered all over the world. And the political economy matters because these are companies that are all looking to profit. And so if they're able to hire Kenyan workers at a lower cost including cost of compliance, then it would take them to hire local workers, and that is what they will do. And similarly, as we all know, they create products and services which are then externalized to global markets, and that's also important because that means that whatever they make is subject to multiple regulatory systems, and products that are not permitted in Europe and not permitted in the United States may exist in other parts of the world. And so, little example of what happens when AI has global value chains is materials that are used to construct AI are mined in other places. If you're interested in this, Kate Crawford has both her book and her beautiful essay with Joler online discuss the physical infrastructure of AI and the global value chains involved. And then with AI, what we have is also an introduction of cognitive labor. Several of you may have read about content moderators in other parts of the world, and AI is now using Kenyan workers to do what they call data enrichment, the whole cleaning up of AI. Why is ChatGPT polite? Because Kenyan workers work for less than $2 an hour to make it less toxic. And so there are people who are involved, there's labor, both cognitive and physical, that is involved in the construction of AI, and that labor is scattered around the world. And then the market. Unfortunately, I haven't brought you pictures of this time, but I was reading the story of how Microsoft was involved with the local Ministry for Education in the province of Salta in Argentina to create a system that claimed to predict teenage pregnancy by going and asking very young women between the ages of 10 and 19 a series of questions that did not contain any questions about sex education or access to any kind of preventive measures, because this is Argentina, and questions of abortion and pregnancy prevention are fraught. And so they basically go and ask them a series of questions like how many people are in your household, what is your income level, etc. And the promise of the system, it is not clear how, was that they will identify the likely teenage pregnancies and the likely dropouts. And no men are involved in this questioning. So the focus is entirely on women for these systems. So there's a series of articles on this. And luckily what happened is that there was the activists in Argentina questioned it and pushed back. But news reports also indicate that that similar systems were being built for other provinces in Argentina and were being built for Brazil as well. I'm sure that I don't need to tell you what the problems of these systems are. Whether they work or whether they don't work, they create several sets of problems. And it wasn't clear what they were planning to do with this information or with the labels that they created. And an American company was involved with this. The other one, which I'm not going to get into for concerns, because of concerns about time, is that if you check news reports, you'll see that the American immigration system often uses automated translation, which it takes seriously in deciding whether to give someone citizenship or not. And one of the stories that I read that really shook me was that an Afghan refugee was describing her journey fleeing to the United States to get citizenship. And her citizenship was denied because the automated translation system translated a word that means I to we. And the judge that read it found the translation inconsistent with her testimony, which was that it was just me. But the inconsistency was introduced by the algorithm. Now, as someone that can speak Hindi, I can totally see how this happened because the word hum in Hindi can mean both I and we. But if you speak English, apart from the royal we, there is no circumstance that I can think of in which you would use the same word for I and we. And so clearly, whoever had constructed this system hadn't thought about a different kind of language and possibly hadn't even thought that it might be used for an immigration system, but it was. And it had a truly tragic impact on someone's life. And so these systems are used at borders on vulnerable people. They are used around the world. And I think it's very easy for people in the United States to feel like this will never affect them, but hopefully I'll convince you that that is not necessarily the case. Because the question is, why should we care, right? And the legal reasons for why we should care is that informational capitalism's legal order is building on global capitalism's legal order. We already live in a world in which sweatshops are used. And so whenever I've been describing this paper to various people over the years, including Anupam's seminar class, which is very helpful with feedback. And a lot of people said, well, what are you describing that's different? And I said only some things, because informational capitalism builds on regular capitalism and builds on global chains that global capitalism has always been using. And so we have had sweatshops, we have had circumstances in which countries are obligated to open their markets to products that they wouldn't necessarily like to let in. And we already live in a world in which pesticides that are created in the United States and then banned in the United States can be sold in other countries. So that's a part of it. But with informational capitalism, there are new problems. And again, I think that the last session, for example, did a great job of telling us why it's hard for us to predict the scale and the enormity of some of the risks that AI creates. But there's another layer to this, which is that the law plays a role in defining risks and harms. And so does public discourse. And so if we're in countries like the US and Europe, and they're choosing to define harms in particular ways because of how their populations are being affected, then there are certain kinds of risks and harms that don't get identified because they're not currently proximate in the countries that are doing the defining. And so there are a set of people that are left out. That is, people that occupy marginal positions in AI's economy, people who are affected by algorithmic decisions, who are not powerful and are unable to access remedies or are unable to articulate how they're being affected. And then there are also people that are just in countries that will not regulate to protect them. And the only way you can access remedies is through local laws. Okay, so this is and maybe you disagree with it. So why should we all care? I think that everyone is eventually affected by this, and I'll explain the killer tomatoes. It's because if you think of pesticide as the analogy, right? So I'm forgetting the exact name. I can give it to you later. There was a pesticide that was banned from being sold in the United States that was then used to grow tomatoes in Mexico. The tomatoes were then sold in the United States and ended up causing paralysis to some of the people that bought them and ate them, because they had such small quantities of the pesticide that when they were being imported, there was no detection of the fact that this product had it. And so we do live in a globalizing world, which means that a problem that may not be local can boomerang back to a state. That's a part of it. But if you also go back to what I just told you about the pregnancy detecting system in Salta, it's also, so states' political consensus and legal order is not static, which means that if a harmful or dangerous algorithmic product exists somewhere in the world, there's a possibility that it comes back to a state when it is politically vulnerable or when the political consensus about how to regulate has changed. And I think that in the US, the debates about abortion have shifted so dramatically in the last few years that it is now not hard to imagine that there may be a time in which an algorithmic system for detecting women that may want to abort future children may have a market within the United States. So I think that it is actually in everyone's interests to take control of AI's global legal order and to make sure that it doesn't result in the proliferation of dangerous products around the world. Thank you so much for being patient.
Thank you, Professor Arun. So Houchin, when you do a book on these proceedings, I think you have a good title, a provocative title in Kangaroos, Avocados, and Tomatoes. We are now, oh, lemons. Got it. So now we're going to hear from Professor David Erdos, who is Professor of Law at the University of Cambridge.
Thank you very much. And I'd also like to thank Houchin very much for inviting me and to the whole Hong Kong University for such an interesting topical set of questions which we're all discussing. So what I'm going to talk about is the search engine cases. So in Europe, the regulation of search engines and what that might tell us about generative AI today and the challenges which are going on in regulating under data protection, that technology. So both search engines and generative AI are clearly AI systems. I mean, they use AI at least, particularly the prediction in search engines. But beyond that, you might think, why should we look at these things side by side? I mean, after all, the chronology seems rather different. Search engines, well, there was a concern in European data protection with search, even news searches in terms of news indexing was a concern of some data protection authorities as early as the mid-1980s. But when the search engines came on within the World Wide Web in the late 1990s and early 2000s, they were seen largely as out of reach. And indeed, there was a sort of loss of nerve in terms of trying to regulate this space. There was some focus rather on limiting the exposure of certain types of data to the web. No robots, various decisions like judicial decisions, the French Data Protection Authority famously said shouldn't even appear online, and these sorts of things, at least if they haven't been anonymized. It wasn't until many years later, 2007, 2008, that the Spanish regulator, with some wider support, started to make the argument that controllers, search engines were controllers in data protection, at least ex post. And it wasn't until 2014 that we finally got the Google Spain judgment, which confirmed that logic, and we had the working out of its reach and its limitations ever since. Generative AI and data protection appears to be very different. It was only the beginning of last year, really, that there was the mass spread of generative AI, particularly in the form of chat boxes, and that's what I'm going to be focusing on, so particularly ChatGPT and Google Bard. And within months, March and onwards, there were investigations. The Italian Data Protection Authority, as we all know, banned ChatGPT, at least temporarily. The European Data Protection Board created its task force. And we've seen statements from data protection authorities throughout the year in the G7 and in the Global Privacy Assembly resolutions, really strongly stating the law applies. And the GPA resolution goes into some detail about what that means, legal basis, data quality, so on and so forth. So it seems really rather different. There's a much stronger focus, a much earlier focus. On the other hand, when you actually look at what's going on the ground, we see more commonalities and very unclear realities. So this is largely based on an initial analysis of ChatGPT and Google Bard. In my opinion, there isn't really a clear legal basis for a lot of what's going on. Yes, legitimate interest is mentioned. There is some mention of what that might mean, but we know this is always totally insufficient for special category data, health data, political opinion, trade union membership, and so on and so forth. And there doesn't seem to be a mention of that. In terms of the transparency notices, Article 13, Article 14, really, the categories of personal data are left totally very unclear. The storage period is left very unclear. What about other substantive standards? Well, accuracy and other data quality issues seem to be problematic. Indeed, Bard states that it sometimes gives inaccurate or inappropriate results. And what about subject rights, control rights? Well, ChatGPT says we may not be able to correct the inaccuracy. Well, how does that relate to the right to rectification? So the question then becomes, maybe search engines' trajectory and its case law are strongly relevant and will become strongly relevant, particularly, I sort of predict, it's always very dangerous to do so, that if these things come to court, we may see Google and we may see OpenAI seeking to rely on these cases. So I'm particularly thinking of Google Spain, paragraph 38. Google Spain is seen as a decision which very much was a great victory for data protection, but actually it limited data protection in quite far-reaching ways. So a search engine was a controller, yes, but only really when it significantly and additionally affected fundamental rights. And even then, only within the context of what the court called its responsibilities, powers, and capabilities, whatever that means. So that limitation is far-reaching, and we need to unpick it in this new context, if it applies. I'm not saying it should. Then we also get freedom of expression, or its sub-right, freedom of information, confirmed in the later case, now in the GDPR era really, of GC et al., saying that it could be invoked. Although a search engine was clearly not a journalist, it can't have those sorts of exemptions. It was pursuing freedom of information, and the law could kind of give and take on that basis. So what does that mean in more detail? Well, let's look at substantive freedom of expression limits. These have enabled search engines to argue that they can self-legislate on the substantial public interest to continue to process sensitive personal data and criminal convictions as well, criminal allegations and things like this, regulated data under Article 9 and Article 10, so long as it's strictly necessary for protecting freedom of information. There doesn't need to be a legal basis in the national law, which is what these provisions were designed for. I mean, they explicitly say so. Google can simply make its own assessment. What about accuracy? Well, again, in invoking freedom of expression, we're told that if it's a minor inaccuracy, it can stay. That's not the normal provision, but that is the provision in the TU and RE case in 2022. So do we see ChatGPT, for example, potentially moving into that territory of trying to invoke this sort of thing? Well, I would argue, yes, we probably do. Look at the removal form here. We see under relevant prompts talking about their assessment of what is in the public interest to have in their database. And we see, are you a public figure? If you're a public figure, give me the context. Well, they're not pointing to any legal basis for things like sensitive data, which allow them to make determinations primarily based on these broad notions of public interest, substantial public interest in the sensitive data case in the search engine cases, or public figure. They're sort of putting this in there in a very similar way to Google's removal form. Okay, so what about the responsibility limitations? I mean, responsibility powers and capabilities. Well, these are extremely far-reaching. They've been clarified again in the TU and RE case, that search engines uniquely only need to operate after the event. They can process data which actually is illegally processed. It doesn't have a legal basis. It's been put there on the internet without consent, for example, and it's sensitive, or it's inaccurate or irrelevant. And so long as they haven't had the data subject contact them and say there's a problem, they're scot-free. And even if the data subject does contact them, if the data standards like accuracy are at issue, we were told that they cannot be required to investigate on their own account in any way. The data subject has to provide all the evidence to prove inaccuracy. That, again, is not the normal law. Indeed, the right to restriction is absolutely about saying, I'm contesting this, you have to verify the accuracy of the data. So again, do we see this as potentially coming into play with generative AI? Well, in some cases, in some senses, you might say, no, we don't. The data protection authorities have really stressed ex ante, we heard this yesterday a lot. Data protection by design, which is the very antithesis of saying, my system is now not capable of complying, and therefore I shouldn't need to comply, give me a free pass. Data protection by design says you violated an additional standard there by not designing it in. Data protection impact assessments, again, strongly stressed by data protection authorities. Proactive transparency, again, an ex ante a condition. The Italian Data Protection Authority put strong emphasis on that. But on the other hand, limitations, yes. Rectification, as I say, ChatGPT seems to explicitly say it can't do it in all circumstances. What about that right to restriction, which enables a freezing of the data when the data subject objects pending investigation? Well, it's not mentioned as far as I can see, and the burden of proof as regards an inaccurate or alleged inaccurate claim coming up in these in this data set or in the results remains unclear. And are we talking about the processing, or are we just talking about the results which come in when someone asks a question to this vast database? Well, the non-user considerations in the privacy policies, and I have to say they seem to be all jumbled up with the user, so it's very difficult to parse out what bit is which, seem to only really focus on the results. And that brings me to the last element, which is the limitation based on significant and additional rights risk. So the Court of Justice has always interpreted this conceptually. We're told that a search engine is responsible in particular following a search on someone's name, but that is because it is liable to significantly affect fundamental rights. So we can think of all sorts of other ways in which searches, the availability of a search engine, can significantly and additionally affect rights which aren't based on a name search. If I take a photograph of someone or find a photograph and search on the basis of that, clearly that's a very significant and additional way of processing. If I search on someone's private mobile telephone number, which they don't really want to be linked, but someone's linked it somewhere in the web, that would be. And the Italian Data Protection Authority actually is actively enforced on the search based on someone's job title rather than someone's name. On the other hand, Google, and we are overwhelmingly talking about Google here, has resolutely limited the right only to name searches. So this is interesting that this conceptual basis, passing it back to the search engine in practice, has resulted in even more limitation in terms of you can't really expect anything unless it's an issue with a name search. So is that relevant to generative AI? Well, the removal form doesn't talk about a name search. It doesn't talk about someone asking explicitly, is this, David Erdos, is he a good egg or something like this? It does talk about prompts. Prompts could be broader than a name search, but we're not really told whether they'll consider some prompts as too remote, but it could be a potentiality. More of a significant and additional threshold seems to be at play as regards training data. ChatGPT tells us that training information does incidentally include personal information, and clearly it also includes vast amounts of sensitive personal information, but there seems to be no clear route given for access, control rights, objection, or anything else, although I understand this is under DPA examination. So, taking stock, even in Europe, search engines are, rightly or wrongly, not subject to data protection. They're subject to data protection light. They're subject to data protection with very considerable exemptions, despite other Court of Justice case law saying only the exemptions which are in the GDPR are permissible, no other exemptions are permitted. They've self-created vast exemptions for particular operators. Those exemptions enable a balance to be achieved, in particular with freedom of expression. They are performing a function. However, they are in essence contra-legislative. They go directly contrary to the legislative text, and they grant operators great and often disproportionate discretion to basically set the rules for themselves. And I do think we see very similar signals that this is where generative AI is moving in terms of its interaction with data protection. And I think there must be a better way. I mean, where is the legislature here? Where is the legislature setting its own exemptions and derogations, and us having that societal debate about where we want the balance to lay? Do we really want to leave it to Google and to OpenAI to do all of that themselves and then come to court later and say, please let us carry on? I suggest maybe not.
Thank you, Professor Erdos. We will now hear from our final panelist, Professor Douglas Arner, who is the Kerry Holdings Professor in Law here at the University of Hong Kong Faculty of Law.
Thanks very much. And I just wanted to echo, I think everyone else in thanks and congratulations to Hao Chen and Grace in particular for putting together this event. But I would also, coming from Hong Kong U, like to thank all of you for joining in what has been, I think, a really great event and discussion, and in particular for all of those of you who have come from outside of Hong Kong. We're very happy to have you here. Essentially, what I want to talk about today is a specific context. Basically, I work in the area of, well, it's the interaction between finance and technology and their relationship to broader developmental issues, and how we can use law and regulation to maximize the benefits and minimize the risks. And what I want to talk about today is a specific context, the idea of open finance. Open finance really is this intersection between finance and data, and I would suggest increasingly AI. What I'm talking about today is a paper that I'm working on with one of my colleagues here, Menglu Wang, and essentially it builds on a series of work that we have done on issues of technology in the financial sector over a period of years. In particular, a book that has just come out, a couple of papers looking in particular at the EU experience, at platformization, and particularly at AI and finance, as well as more recently a series of papers with other colleagues looking at essentially data governance issues. And I think the starting point is a bit definitional. If we think about these topics, open banking, open finance, open data, essentially the idea here is the argument that if customers in financial services are empowered to enable use and access of their data by other providers in the financial services industry, that this will have a range of benefits, in particular from the standpoint of empowerment and individual control. Second, from the standpoint, particularly if we look at the open banking genesis in the context of the EU in the second payment services directive, the idea of breaking the dominance of banks in the context of data and payments more generally. Third, the idea that enabling wider access to data outside of the banks, which were seen as controlling, would have a benefit on increasing competition, supporting innovation, which in turn would drop prices and enhance efficiency, particularly in the context of cross-border payments markets. And finally, the idea that if you enabled consumers to control their data, to bring it outside of the banks, that it would enable aggregation of data, which could then have positive benefits. And I think if one thinks about the key definitions, open banking is basically about requiring data sharing by banks. And if we think about the EU context, it's very interesting because the effective, 2018 effective year for both PSD2 and GDPR is the same. And in many ways, the obligation that is in PSD2 is almost parallel to the GDPR definition. But I think this highlights something that often when we're thinking about finance, we never talked about data protection in finance from the standpoint of things like personal privacy data prior to around 2016, when we began looking at the extraterritorial impact of GDPR. Now, one of the big reasons for this, as I'll highlight in just a minute, is that finance actually has a long history of its own legal and regulatory frameworks around all aspects of data, which in some cases have conflicted with other forms of data regulation and control. Now, open finance is about mandating not only banks to allow access to information, but allowing other institutions across the financial sector, which may include insurance companies, which could include tech companies, whoever may be participating, to mandatorily share data of customers. And of course, one can then expand this more broadly to the idea of open data. If we look at this from the standpoint of models, we've largely seen three different models arrive. One is a sort of market or industry-led, the idea that doing this sort of approach is in the industry's interest, and therefore it will happen by itself. The various jurisdictions, including the US, that have taken this approach, it basically hasn't worked. And we see right now in the context of the US, there's an explicit proposal from the Consumer Finance Protection Bureau to create a new personal financial data right that would enable the mandatory direction of personal data in certain specific use areas across particularly banks, but also certain other aspects of the financial system. We have systems that are called regulator-led. I would say China, India, and Hong Kong. Hong Kong, at the moment, in the process of building an infrastructure project for data sharing, which is called the Commercial Data Interchange, provides a good example of that. And you have an increasing range of jurisdictions, which we can call like the EU or Australia, the UK, Brazil, which are moving to mandatory data sharing frameworks. Now, I think when we're thinking about finance and data and AI more generally, it's helpful to think about, I think, three facts. Finance is one of the world's most globalized industries, and I'm not really going to look at cross-border today. It is one of the world's most digitized industries, and I think that's very important because as we think about where has AI been used and developed very extensively, the financial sector has been one of the leading spenders and developers and users of AI. But the third piece is finance is one of the world's most regulated industries. So when one is thinking about these new technologies, it's invariably the case that it is coming into a regulated context. And I think if we think about the digitization, it's helpful to remember that we can think about NASDAQ as the first fully electronic stock exchange in the 1970s. We can think about, from a risk standpoint, 1987 stock market crash caused by program trading. That is automated programs selling on preset buy and sell orders. We can think about the 2010 flash crash. We can think about a series of examples that I think really highlight the digitization. From a standpoint of regulation, I think it's important to think about that when we are thinking about finance, there are a series of very well-developed regulatory objectives and systems of regulation that basically come into more or less any technology that you're dealing with. Monetary stability, less important. Financial stability is all about prevention of financial crises. Market efficiency, the idea that standardization is very important from the standpoint of market functioning. Consumer investor depositor protection, the idea of protecting consumers both from financial industry predators as well as from criminals and miscreants. One of the most important, market integrity. This is all about AML, sanctions, corruption. And finally, broader sorts of growth objectives. So when we think about data regulation in the context of financial services, we can actually think about banking secrecy dating back to the 19th century as a fundamental framework mandating the protection of individual data by the banking industry across most of the world. Oddly, the 20th century was about, in many ways, breaking that down across a range of different areas. And we can see specific rules coming for customer information and records from the 1960s. In other words, banks have to keep lots of records about your transactions because, after all, if you have a bank account and the bank doesn't keep records of your transactions, you really have no idea what's happened to your money. So we have regulations that specify very clearly what they have to keep, how long they have to keep it, and it's digital. Second, market information. Vast amounts of information that has to be reported basically from the standpoint of trading, fraud, etc., all in a standardized format, which means that financial institutions spend a huge amount of money basically building systems to collect, maintain, and deliver customer data according to a variety of different regulatory requirements. AML, tax, and corruption. This is something that has basically broken that bank secrecy framework, and something that if we think about some of the privacy protection legislation around the world, one has seen very direct conflicts between some of the market integrity and money laundering rules, which have very different genesis. We can think about credit information. Credit information, most jurisdictions have mandatory sharing of credit information by banks. In other words, this is something that there's often a credit bureau or a credit reference agency that banks mandatorily have to share information with. Why? It's largely about fraud protection so that you don't see individuals rising up and borrowing huge amounts from large numbers of different financial institutions, which is not only a fraudulent issue, but it may also cause financial stability issues from the standpoint of the lending banks in the event of non-payment. Cybersecurity, this really starts in many ways with Y2K and 9/11 and continues right up into the present. In other words, if we think about data security legislation in financial services, this is something that has a long history. Finally, payments. Now, in some ways, we can see in the EU all of these pieces coming together accidentally across a series of directives and regulations, which all coincidentally came into effect in the same year. And one can argue, basically say, had a complete transformative effect from the standpoint of digital finance in financial services. So from the standpoint of AI, where have we seen this in finance? Basically, securities trading has been the genesis area and by far the biggest spend, not surprising. The second has been payments and fraud. Think about many of those of you who are visitors, and maybe you used a credit card somewhere in Hong Kong and your bank sent you a note saying fraudulent transaction. Yeah, that's AI. One of the best examples where we've seen is in this context, credit and lending. This is the Amazon or Ant massive amount of data use from the standpoint of credit evaluation. And we can highlight a series of others. But I think the key is as we think about data and aggregate data, what we see in the financial services context are increasing efforts to figure out how can we maximize the benefits of data, in particular aggregate data, which feeds AI, but also address all of these ranges of regulatory issues. And I think if we look at the lessons from the open banking finance and data experience so far, the takeaways are that voluntary doesn't work. It has to be mandatory. Second, you need enabling infrastructure, particularly digital identification frameworks. And the third is that it can't be just banks. It has to cover every financial institution in a given jurisdiction. Thanks very much.
So Professor Arner, thank you. And he absolutely cannot be accused of standing between, himself and your lunch because he's came in under time. Thank you so much. We have ample time now. Well, first though, thank you to all of these panelists. These were fabulous presentations. We're going to turn it over to all of you for questions and comments. And please introduce yourselves and also turn on your microphones. So let's start with you.
Okay, so hi, my name is Xiao Wei. I'm a postdoc from Hong Kong U. So my question is for Professor Penney. Chilling effect is definitely a very important issue to regulate in data protection field or in a more broad field. And I noticed that you built upon your chilling effect reduction act based on a data protection framework. And then it reminds me of our discussion between risk-oriented arguments between with risk-based approach or scale-oriented approach that is proposed by Professor Yu and Professor McKenney. So I want to ask your opinion: is the cost and benefits approaches apply in your framework? And also, if other two professors, if they are willing to join this discussion, like I would love to know how your risk based approach or scared concept can be applied to reduce chilling effect in this case. Thank you.
So that's a great question. And certainly, I mean, one of the things I talk about in the book and inevitably with a lot of these different schemes, and that includes, data protection legislation, the right to be forgotten. You often have these competing interests, right? In fact, often you have competing chilling effect concerns. That is, in the United States, for example, often when you have debates around the right to be forgotten, there are often proposals like this are critiqued for having a potential chilling effect, right? That and Google and often companies, sort of are big on sort of pushing this framing. But on the other side of that is the reason why you'd be enacting is that you're attempting to protect certain privacy interests to avoid also a chilling effect, right? My work with Daniel Citron, where we've looked at, for example, well-tailored anti-abuse measures online, often opposed for potentially have a chilling effect on speech, actually, if done right, can have a salutary impact on speech and engagement, especially for those who are disproportionately victimized by forms of online harassment and abuse. But even there, you have competing concerns around chilling effects. So I know I didn't quite get into it in my presentation, but certainly, there's often a balancing here, and I think that works well within Professor Yu's sort of risk-based framework, right? So if you're concerned about chill, in ways you can think about my recommendations or how you design data protection to minimize. What I'm saying is minimize the risk of chill. You can't eliminate it, right? And in fact, it's a reality of our interactions, right? But there are ways we can do things better to mitigate it, reduce the risks of a chilling effect based on certain kinds of threats. And that's what I'm suggesting. So certainly you can think of costs, you can think of risks, you can think of balancing of competing frameworks. It's certainly not an absolutist framework. It's more of understanding the impact of certain measures, certain practices, and taking that into account in designing laws.
Professors Yu and McKenna, would you like to respond?
So I find myself fascinated, Jonathan, thinking about your framework. We're lapsing very much into the traditional notion of chilling, the negative stuff. But if you're talking about your conformity aspects, the risk profile is completely different. In terms of your factors, about the threats, there it's things like groupthink, herd instincts, these sorts of things. And then you have to do a completely different set of risk assessments to try to figure it out and to figure out how, and a lot of good social science to realize how that's going to go. Now, the American reality is you're going to run smack into the First Amendment. We're going to find this out. There's a Supreme Court argument, I think it's set for February 8th for the net choice cases, which based on the shadow docket, most of us think is going to put up a pretty big roadblock to this. So in the US, it's kind of an interesting exercise, but is unlikely to be able to be realized in law. But I mean, just thinking it through, forget about restriction on the government end. This is then applied to companies if this is a real risk. And in a world of fake news, in a world of, content moderation, hopefully it pivots into something where it becomes a risk management issue addressed to those companies. But unfortunately, they're going the other direction right now.
And maybe just, I think that's a great comment, Professor Yoon. I think thinking about the American context, and I know there's other scholars who made this argument, like Neil Richards, for example. Ironically, what I argue in the book is if you look at the empirical literature on chilling effects, ironically, the way American First Amendment jurisprudence in this count is set up, the claims that the court gives most credence to in the chilling effects doctrine in First Amendment claims has the least empirical foundation out there, right? That the claim that a regulation, right, has a chilling effect. The literature says, you have to have very specific conditions have to be met for that to be the case. Of course, there are chilling effects from targeted prosecution when someone knows they're being pursued individually. And we don't need to look at more recent evidence of that. We have testimonials from, activists during the civil rights era who were targeted by police prosecutions, for example. But when it comes to vague regulations, that's the kind that the Supreme Court really loves. But they're very skeptical about privacy-related chill, where I think the balance of the evidence, especially when I argue drawing on the social science literature, is far more powerful and compelling evidence of that. So I'm arguing that the doctrine has to change. You're right. It's unlikely to happen soon. So then my target is redesigning data protection laws, making the case to companies to achieve the same way, but not through these sort of concrete kinds of litigation.
I think Professor McKenna, did you want to?
Maybe just a little quickly. So one is that I think that, the idea that certain kinds of like social, what you call chilling effects or others, like the kind of stuff Neil writes about, right? And certain kind of like social costs to various kinds of privacy regulations, I think fits the scale as different kind of model pretty well, right? The idea is like, you might think about facial recognition as being, one sort of narrow way of thinking about the cost of that, or have to do with like the monitoring and the surveillance of individual people. The second order question is, what is it like to live in a society that is under constant surveillance, right? That's a different kind of thing that emerges at scale, right? Only when you're not just talking about the images of your own face, but in like a place where, to get on the airplane, when I came here, I had to look into a camera and I was not given an option about that. I tried to explain that I didn't want to do it and they had no interest in that. But the other thing that I thought was interesting about, one of your takeaway points, which was that the idea that giving people constant notice actually has the kind of perverse effect of reminding them that they're under surveillance is also another example, right? I think where we think normally about the costs and benefits of notice being about the choice of individual people, but that actually it has this other unintended consequence of reminding them of their constant surveillance. So.
Okay, great. Why don't we hear from Professor Chander, then Professor Veal, and then we'll take a couple more after that.
Good. Let me see if I can hold this down. A great project and a really wonderful exercise. And I think, as you rightly point out, we're going to see a large kind of investigation of this issue over the next year and longer. But I'm going to ask you about the differences between search engines and AI chatbots, because let's think about when a search engine produces personal information and a chatbot produces personal information. Do you feel that those two actions are different? That is, if I can Google this information about you, should I feel now more concerned if I can ask the chatbot that information about you? Should the two regimes for personal information be different in that way?
Yeah, no, it's a brilliant question, and it is in a way the $1 million question that which will come live. I mean, a search engine is, in some sense, and it would argue strongly, although it's not as strong as it makes out, an intermediary. So, you know, what really undergirds the argument is that the original website, you're being directed to it. You can click on it. You can go to that site, and if there is an issue, potentially you can also contact that site. And it's sitting between, as well as having some independence. There are some major differences with chatbots. You know, they are users of data in a much stronger sense. They manipulate and change the data. They can hallucinate themselves and come up with things which weren't even in the original data. But even if they're not, their sources are unclear. I mean, it generally, actually partly due to copyright concerns, they're very reluctant, but also because of just the way the network works, it doesn't really know why it's saying this at all. Now, interestingly, Google Bard does have some sort of function where you can press a button and it will try and find things on the web which back up the claims. But even it says this isn't necessarily why the chat box thinks that these claims are true. It's a separate analysis. So it's much more similar to, you know, a researcher going out and writing a book, or, you know, I mean, it's much more independent. It's using data, sure, but we all use data, and it's coming up with something new. So I think that the claims, such as they are, because they don't really have a legal basis or a clear legal basis, but such as they are, to sort of give search engines these special dispensations, because really they should only need to act when it's significant and additional, because there's something fundamental behind the operator, and they're an intermediary, and intermediaries have notice and takedown understandings, even if it's never really been properly codified, are much less strong when it comes to generative AI. And we need to think that, you know, this is the beginning of generative AI. Generative AI will take over more and more areas of life and will become more and more integrated into day-to-day activity in firms and other organizations. And we really do not want to end up in a situation where we're sort of saying, well, that's not really something which should be looked at unless maybe after the event and on an ex post basis. I mean, that's a huge restriction on rights, and we're not really thinking through as this sort of technology maybe takes over a lot of life, what that could amount to.
The one thing to throw out in the US Google case, the testimony is saying that search engines are all incorporating LLMs. And so the big distinction between them seems to be collapsing, and that they're feeding, that's the primary driver for Bing's improvement, right?
Professor Veal.
Thanks. So also a question to David, and I was going to raise the same point as Christopher did, just as a sort of follow-up for that one. My question is a bit different. When we're thinking about a search engine or an AI system as delivered through an API or a website like ChatGPT, those are similar in some ways. It's actually a service. You don't really care if it's a model, because it's actually going to be a model, and there's classifiers on top of it, and there are like detections to stop you writing in certain things. It's actually a whole service, a software stack that's delivered just like Google search. But models are also, you know, made available, coded available, moved between organizations. They're not always delivered as a service. They're also actually independent things that are considered with exactly the same challenges you laid out. And so how far does the search engine analogy continue when you have a company like Meta releasing a model that is then stored on many people's computers and is not delivered as a service through a website or an API?
Yeah, I mean, well, you're sort of talking about, I think, that the distinction between provision of equipment in a way, or provision of means, and being the controller, I think. I mean, if it's purely a case that you take even a very, very advanced system of software and you run your own data through it, and you remain in full control in a sense of what you decide to use the tool for, then under current analysis of the current law, the controller would appear to be just the end user, actually, who's deciding to use this technology. Now, that technology, because of its limitations, may be wholly illegal, but nevertheless, the decision is being made by that entity to use it. and they need to bear responsibility for it. If on the other hand, it's being managed, updated, and organized subject to terms on a server owned by the AI company, but they're inviting the input of data into it, that looks very like the joint controller case law that we've seen develop in under GDPR and is very, very far-reaching. So we know that even a Facebook page of an organization makes the organization, I mean, what this amounts to is really quite unfathomable, but the joint controller of the underlying data processing that Facebook is doing on those who land on the page. So, you know, it would seem that there is a similar nexus there of both entities, and they need to take joint responsibility, and there needs to be a joint controller arrangement, and it needs to be transparent and everything else. But we're close to it being shown just how much there is a gap between, you know, the realities and the letter of the law, because where are these arrangements? I mean, across the board. I mean, what happened when Facebook organizations were told that they were joint controllers of Facebook? That was years ago. What on earth has happened? Has anyone actually in most of the relevant jurisdictions sat up, you know, smelt the coffee and fundamentally changed their practices and taken responsibility for whether Facebook's practices are or are not illegal? Which really, frankly, there may be serious questions about their legality, which are still running through the courts, years and years and years and years of it. But in principle, every controller in every European jurisdiction with an organizational page should be taking responsibility for that analysis. But I don't see that happening. And so we're sort of back to the smoke and mirrors nature of much of this, but that is where the case law is at.
So we're going to hear from Professor Sun next, and then we'll go to you and Angela. Oh, sorry, wrong name. So we'll do this order: 1, 2, 3.
I have a quick question for Professor Arun. I admire your courage for tackling, global issues concerning AI, especially your courage for, your care for marginalized group of people. But I wondered how we should deal with such complicated issues. I mean, when it comes to discrimination, if you want to tackle discrimination within a country, it's already a very daunting task. But if you move it to the global stage, I believe it's going to be a lot more complicated and daunting as well. And just think about how many different kinds of group of people we have in the globe. And another issue is about language. I think languages are very important. I'm very concerned about the disappearing of more and more languages that people have been using around the world, especially in the age of AI, because English currently is the dominant language when it comes to the usage of ChatGPT. How do you think about we should deal with such complicated issues? Especially, my question actually is about human rights. How would the international human rights, patchwork still be relevant for addressing, the issues that you shared with us? For example, the right to language.
Thank you. That's a very helpful question, and I really appreciate it. One is, I want to say that I'm very aware that mine is a very broad project. I think that I'm lucky that my mentor is someone that does write about big questions. Most people would have been like, don't touch it. But the good thing is that I kind of wanted to learn to think through these seemingly daunting questions from him. And so this has been 2 years in the making, the last paper. My Carnegie essay is in the process of editing. And I'll tell you why. It's related to both questions that you asked. One is the global discrimination question, right? What I'm getting at is basically suggesting a process that enables democratic voice. And that is challenging, as you point out, because even within countries, there are marginalized groups. But I think my worry is that when the global companies go into these countries, they do two things. One is that they enhance the inequalities within the countries. And the second is that they potentially create new problems, sort of leveraging those inequalities that people either don't detect or aren't able to fight. And like, classic example of the first problem is that India has a huge caste issue. Facebook had, well, now I think it has its maximum number of users in India, but for years it didn't use caste in its definitions of racial discrimination. And for years, we used to tell the Facebook public policy people that you can't ignore caste when you are in India, because we both have caste discrimination, but we have a very particular and interesting framework for dealing with caste discrimination because our constitution was drafted by someone who's from a marginalized caste. And so he understood it like no one else does. But it took Facebook shaming from Motherboard 3 years later for them to even consider getting into the question. And in the meantime, they were publishing material that was arguably illegal in India, but definitely discriminatory. And that's miles compared to what happened in Myanmar, right? So that's partly why I'm worried. And when I said capitalism's legal order, this relates to the human rights part of your question. Quinn Slobodia has this wonderful book called The Globalists that talks about how the global legal order was constructed using institutions that protected the flow of capital through bilateral investment treaties, through the WTO, et cetera, but sort of confined the democratic discourse and the fight for rights to local contexts, which means that we have a great like international human rights norm system, but it's completely unenforceable. And so you always have to go to your local court to get a remedy, but the local court is now concerned about what happens. Well, partly the local court could be influenceable or ineffective, but even if it is effective, then geopolitics means that a more powerful state in which the company is housed can now pressure the state that is trying to confer rights on its citizens and be like, well, global trade is affected. And that problem that Quinn Slobodia points out in his book was almost intentionally created by neoliberal thinkers to say that we need to protect the flow of capital, but not enable people fighting for labor rights, for example, to go outside their country. That is what I'm worried about, and I'm worried that it will sort of consolidate in the context of AI. Do I think that we'll come up with a perfect solution that addresses everyone's issues? But I think that as people that are thinking through legal regimes, we can think through legal regimes that offer different spaces for the voice of movements and that enable mobilizing to get the different stages of AI law to account for as many marginalized people as possible. So that's part of it. The language question is fascinating. I don't think that my work necessarily permits me to give you a good answer for it. But I would point you to Karen Howe's work on the Maori people in New Zealand and how they managed to use AI to preserve their disappearing language and culture. Yeah, I think that you might find that interesting.
Thank you.
Madhavi, would you like to collect questions first and ask, panelists
Okay,
to
so I
quickly
think we're
respond
going to
in
take
interest of time.
these two and then maybe just two more at the end. So why don't you let's take two at a time. So
yeah, my name is Behzad Mirzaei. I'm a business consultant, and thank you very much for all the panelists. My questions go to Professor Douglas Arner. Is from an open banking perspective, what are the key considerations and challenges in adopting digital assets or cryptocurrencies within the existing regulatory and compliance framework? And how do you see the role of data and AI governance intersecting with these considerations?
let's hear from Professor Zhang as well.
That's great. I also have a question for Doug. I think that your area of research is extremely important in the area of generative AI because the data access in the finance industry is like face a scarcity problem. And the open banking project initiative actually become even more prominent. So my question is like, against this background, how do you persuade individual more willing to share the data for training purpose and also to encourage financial companies to be willing, license the data, to train AI firms to train the data, because I suspect that these big financial companies rather do it on their own, right?
Yeah, I think some big questions there, and I'll try to hit a little bit. I think from the standpoint of let's say crypto and AI, in many ways, there's this hope that the broad availability of information on blockchain can provide an enabling mechanism from the standpoint of AI. Whether or not we can get there or not is an open question, but certainly from the standpoint of on-chain data and transactions, because you often do have, so long as it is clearly on-chain, you do have clear linkages. We are seeing greater and greater use of AI, both from the standpoint of trading as well as from the compliance standpoint. From the standpoint of AI and open banking, and I think this goes to Angela's point as well, there's a very natural linkage. And in many ways, the idea is that if you can break open control of large financial institutions' data, or from the standpoint of tech companies like Ant that have become large financial institutions, if you are able to break up their effectively dominance of data systems and make that available to other participants, the availability of that aggregate data will support competition and innovation and wider benefits. And this, from the standpoint particularly of the open finance discussions, is really, I think, the core idea. And we're seeing different directions from, say, your mandatory open banking, open finance jurisdictions like the EU, Australia, UK, or other jurisdictions which are taking related approaches like China or India. But I think the key lesson that is coming out of all of this is it only works if it's mandatory. And so that's something that we have a long history, particularly in credit information, that even where there is actually a common interest in the banking industry in sharing credit information, they don't ever do it unless it's mandatory. And so one of our suggestions is that, in fact, because almost every jurisdiction actually has a credit information sharing system, that you can often start with this, and you can then include a broader range of institutions or information. And in some ways, this seems to be the approach that Hong Kong is taking with the commercial data interchange infrastructure.
All right, last two questions. Let's collect them. And yes, right there.
I just want to thank you again, and especially Professor Arun for bringing such an important and I think under-discussed issue.
And go ahead and introduce yourself.
Oh, hi. My name is Hai Liu, MIT. And I just want to ask Arun, but also I think just bring to everyone's attention here, because I think, as I said, it's under-discussed. Are you familiar with the work of Chinmayi Gebru, I believe her name is? Yeah. And I just want to read a short quote from a piece that she published in The Economist in November. Those working on the repetitive task of providing examples to train or evaluate systems like ChatGPT or DALL-E do not expect an all-knowing machine on the horizon. They clearly see how hiding the extent to which their labor powers these systems helps multinational corporations sell the supposed power of their technology while exploiting millions of people around the world. These workers are organizing to improve their working conditions and to curb the development and deployment of harmful AI systems. For example, in 2023, Kenyan workers employed by third-party outsourcing companies for the likes of Meta, OpenAI, and ByteDance, TikTok, established the first African content moderators union, and one of them sued Sama, an outsourcing company. These are getting into details, but as noted, a former Amazon delivery driver campaign for better working conditions. The less labor that companies are able to exploit, the less they are able to develop harmful AI systems, because it would not be profitable to do so. I just thought that was very powerful, and I just wanted to share that. And I guess my question is just, how do we bring this more to the forefront?
Thank you. All right, we're going to collect the last question, and then Professor Arun and others can respond directly to the questions, but then you can each make a quick concluding statement if you're invited to do so. So last question, yes. And introduce yourself, please.
Financial data governance. I once read your article about financial data governance. And my question is, do you think the burgeoning EU's legislations for financial data actually covers its financial data governance. I mean, nowadays EU has GDPR, Institute for Open Banking, Law Enforcement Directive, and newly launched FIDA, financial data access, and legislations for credit scoring and cryptocurrency. I mean, many legislations think of EU's legislation regime are patchy and inconsistent. How to achieve the coherence between them? Yeah, that's my question.
And what's your name and affiliation?
My name is Richie.
Great, wonderful. All right, why don't we start with Professor Arun, then Professor Arner, and then the remaining panelists. Response and final thoughts, if you'd like to add.
Thank you.
Yeah, very quick.
Final thoughts are, thank you, this has been a fascinating panel. Responses, we could discuss it more in detail later, but I actually have a deep dive on semi-AI in my paper. And the way to deal with it, I would say, is write and find ways to mobilize, which are challenging because the entire system of microwork is designed to fight mobilization and create competition instead.
I'm going to kind of hit both of these quickly, I think. And I think the first point is, I think one of the most important reasons to look at the benefits of data aggregation is from the standpoint of countries which don't have large enough markets to have effectively sufficient data to develop their own innovations. And so I think this is a real challenge going forward. How do we deal with this sort of division between large jurisdictions that have access to large amounts of data that over time should give them comparative advantages against large numbers of smaller developing jurisdictions, which already are disadvantaged, but simply don't have the data scale necessary. And I think that this is going to be one of our bigger challenges, is how we actually deal with spreading the benefits of aggregate data in the context of an increasingly fragmented global data system, which I think takes us to the second question about financial data governance. I think one of the challenges right now is that we have a number of systems which are evolving to deal with the financial regulatory issues, to deal with some of the data concerns, but really often from the standpoint of seeking to benefit competitiveness and development. And I don't think at this stage we really have a clear answer on which of those directions or approaches is going to work best, which means from the standpoint of countries around the world, it's a real challenge to figure out how to move forward. And I think often the key is, one, to think about it, two, to think about what is going to be your country's approach to data. And as we've highlighted, there are different approaches to that. And finally, to think about from the standpoint of how can you enable the benefits of aggregation, often through systems that may mandate sharing or digital ID frameworks.
Thank you. Professor Erdos, anything?
I'll be extremely brief. I mean, I think that there is some consensus building, including today, that big tech needs to be more accountable at a practical level. That doesn't mean that the law on the books has all the answers or that it's always feasible, but there is a huge accountability gap given the power of these operators. We think back to multinationals in the past and all the issues over things like transfer pricing and the sort of control and power and authority that these new multinationals have is unfathomable. I mean, it's massively more than what's happened in the past. Regulation, law, accountability, democratic participation really needs to get its act together in a practical way that we still don't really see.
Final quick word, Professor Penney.
I mean, I think we're living in a very interesting but dangerous time. There's danger in doing too much, danger in not doing enough. Just to agree with Professor Erdos, I think, and also Professor Arner, he says like the insight from his area is that, voluntary doesn't work, mandatory is what works. And, similarly from a chilling effect perspective, unconstrained data collection with any kind of constraints is a real problem from chilling effects. And it seems like that's also part of it too, that we need to act thoughtfully. But I think there's more concern just sitting back and leaving things to big tech and leaving it to the private sector has proven itself to be a folly. And so we need to act, but do so thoughtfully. Thanks.
All right, well, thank you. Let's all join us in thanking our panel. And enjoy your lunch, everybody.
Yeah, please join me in thanking Professor Sunder for moderating such a wonderful panel discussion. Thank you, Professor Sunder.